We begin this half hour with a new challenge to affirmative action policies on college campuses. This week, the Supreme Court agreed to hear a pair of cases brought against Harvard and the University of North Carolina. The lawsuits allege the school's admissions policies discriminate against Asian American applicants. If the suits are successful, colleges and universities may no longer be able to use race as a factor in the admissions process. Now, Natalie Brand reports on the arguments that could be heard by the court in the fall.
What do we do when affirmative action is under attack? Stand up, fight back!
It's a years-long legal battle that's divided some students at one of the nation's most prestigious universities.
Race cannot be removed effectively from an application just because it is so central to so many people's identity.
We're not against that. Someone should not be providing their racial information. But how is that going to be used is a big question.
The lawsuit that started in 2014 accusing Harvard of discriminating against Asian American applicants is now receiving new attention from the U.S. Supreme Court. Harvard has denied the claims and lower courts have ruled in the school's favor. But the High Court this week agreed to hear the challenge to race-conscious admissions policies at Harvard and also the University of North Carolina.
This case could have a dramatic effect.
Ken Marcus, chairman of the Brandeis Center, has written a friend of the court brief in support of the group challenging affirmative action, Students for Fair Admissions. They believe the new conservative majority Supreme Court will revisit decades of precedent.
Are universities really using race only as one factor among many? Or are they tipping the scales as they want to, based on their subjective considerations?
Harvard's president, in a statement, says considering race as one factor among many in admissions decisions produces a more diverse student body, which strengthens the learning environment for all. Nidhi Shah of Asian Americans Advancing Justice, AAJC, agrees.
Because we know, for better or for worse, that there is discrimination in America today, and there are disparities in education.
Her group is among those fighting to keep affirmative action in place.
We will continue to fight for diverse, inclusive learning environments that benefit all students, including Asian American students.
While Shaw is hopeful past precedent is on their side,
I think the current Supreme Court majority is radically uninterested in paying attention to precedent.
George Washington University law professor Paul Schiff Berman says if the court overturns the past precedent, he believes it will hurt the educational experience for everyone.
I think that the educational mission, the imperative to make sure that universities have diverse perspectives will continue to be an imperative. How universities will do that, I don't know. And certainly the U.S. Supreme Court is likely to make it much, much more difficult.
The Supreme Court is expected to hear the high-stakes case next term. A decision isn't expected until 2023. For CBS Saturday Morning, Natalie Brand, Washington.
We've seen this before. You know, the U.S. military has stepped up in amicus briefs. So have corporations to say, you know, this is really important in places not only of work, but certainly in the educational process. But a different court now, a different perspective now, a different lens.
An always evolving court.